Good morning. I am Liz Wagenseller, Executive Director of the Office of Open Records. I'm joined by Nathan Byerly, Deputy Director, and also we have Jordan Davis, who's one of our Deputy Chief Counsels to help with questions. We are going to dive into some issues. What is going on in the right to know law world? What are we hearing about Sunshine Act? We're going to be talking about things that we have been hearing about, lots of questions. If there's something we don't get to, feel free to ask at the end. We can try to help you. If during the discussion we're having, feel free to put a question in the chat and we will try to answer that for you. So with that being said, I'm going to turn it over to Nathan and we are going to get started.
All right. Just as a couple things to lead off, there's going to be, we already can tell there's going to be a lag with the chat. So just because there's so many in attendance. So if you ask a question, just be patient. We'll try to get to it. The other thing I just want to say is a legal disclaimer. None of the things that we present in this presentation is to be taken as legal advice. Additionally, it's not precedential. So, if you're a requester, don't cite to something we said here and say, hey, this overturns one of the FDs you did. Or if you're an agency, if we give some potential suggestions to things that we see that might make life easier for the arrows, again, that may be something that changes in the future since this is a relatively new area with the portion of our time is that we're going to talk about a new area that we've been facing recently. Today's topics, just to give you a roadmap for where we're going to go, we're going to talk about bulk requesters and some terminology, just some things to go over. We're going to talk about the OOR's new standard right to know request form. We're going to talk about anonymous requesters in general. And then Liz is going to sum up some questions we've seen come in regarding the Sunshine Act and executive sessions. All right, so before we even jump into talking about some of the things we want to discuss today, I wanted to take the time to go over terminology because it's kind of important. We're at the beginning stages of AI coming into the picture of the right to know law. So the difference, a lot of times there'll be bulk requests filed and some people will just, refer to them as anonymous requests or anonymous requesters. I just want to differentiate that just because there are a number of right to know requests filed by one person or entity, it doesn't necessarily mean they're anonymous. We could have situations where they are, but sometimes there's a tendency to push those two terms together. The big one I want to emphasize is automated requests versus AI. And the use of a system or a tool or a software to file a number of right to know requests with an agency or appeals with the Office of Open Records, that we have looked upon as it's an automated tool. It's not necessarily using AI. Sometimes they do, but most of the time these automated softwares are just something that someone has set up or a company has set up that generates those requests. AI is a little bit different from the standpoint that AI is something you can use to generate requests or generate documents. So for example, if you type in there, write a chapter on freedom of speech and you hit enter and 45 seconds to a minute, it just sits there and boom, 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 hammers it out. You could do it in the right to know context of say, you type in there, type me a request for these types of records and you hit enter and within a few seconds, it generates that request for you. Again, that can tie into the use of those automated systems, but they are two separate things that we should keep apart even as we begin to discuss. There's legislation discussions that will be involved in that as well. It'd be important to note that there is a difference between those two. Another one that we often, and I myself do this on a consistent basis, is to mix up resident and citizen in the United States. The definition of a requester is that you have to be a resident. And I know there are agencies out there, and I'm going to emphasize this several times today because I've seen several news articles on it, that agencies out there have passed policies or codes or regulations or whatever within their agency that says you have to be a citizen of the United States to file a request with the agency. And that is not what the right to know law says. You have to be a resident. So keep that in mind as we work through this today and as we look to address the issues. So one of the big issues that's come up that we've had a number of inquiries to our office about is anonymous requesters. And before we get into addressing some of the final determinations, the best place to start is to go take a look at what the law says. And it's covered in section 702, 703, and 102. For the attorneys out there, you can reference that. I'm not going to go into much detail here because we will walk through these in final determinations as we go through them. But it's just interesting to note that agencies may fulfill these anonymous requests. All written requests are to include the name and address, and then section 102 defines that the person making the request has to be a legal resident. And again, I point out that differentiation between resident and citizen. So if you're an agency out there that has citizen in your policy, I would encourage you to change that sooner than later. So just some basics, talking about how to handle anonymous request situations, and use common sense. I know that's a concept that continues to struggle in modern day society, along with reasonableness. But if you have no reason to question the identity of a requester, don't. For example, the requester lives in your area, you've dealt with them in the past. Don't suddenly become a stickler for, oh, I think they might be anonymous, we're going to deny the request based on anonymity. No, work through this in a reasonable and commonsensical way, keeping in mind at all times that the right to know law is construed, and the Supreme Court has said it must be construed to maximize access to government records. Again, all in the context of reasonableness, but we are looking to maximize access to government records as government agencies under this law. Additionally, keep in mind that if you do claim that the requester is anonymous, as the agency, the Office of Open Records is going to look to you to provide proof to show what supports your legal argument that this request is an anonymous request. So we're going to look to you for those facts, we're going to look to you for that evidence, and then we'll look to you for some type of legal argument supporting that. So a brief summary of, and this is a very general summary of the final determinations, the things that we look. As I said earlier, we look at section 702, which gives agencies discretion to process or not process anonymous requests. You, as the agency, have the ability to make a policy that you will not accept that. We encourage, as you'll see later on in the slides, we encourage agencies to come up with a policy that says one way or the other how you're going to handle the anonymous requester situation. Again, it's your discretion. We are not going to step over that discretion and say, what you should or should not do. That is up to you. But whatever your decision is when you come before the Office of Open Records, we will respect that based upon the authority you're given in section 702 to make that decision. The right to know law defines a requester as a person that is a legal resident. And again, emphasizing does not need to be a citizen. And I won't continue to emphasize it too much, but it's something that needs to be changed if you have that in your policy already as a citizen. So the question that arises from this then is, what is a person? And sometimes in the legal world, we know the definition of person. I know a lot of times people just think a person is a human being and that's it. That's where it ends. The requester can only be human. But the definition and legal definition is much broader than that. A person can include any number of entities, corporation, partnership. You see the rest of them listed there. So requesters can be individuals, they can be businesses, nonprofits, government entities, etc. So that enters into the equation as well to determine anonymity being the what needs to be proved there. So looking into how we've handled some of these with specific final determinations that we have gone into. We had one filed where it was, and this was a appeal and then a request and an appeal to our office that just anonymous was written down in the name section versus the Downingtown Area School District. We looked at the case. There was no evidence that this was a person. It was clearly anonymous and would not qualify as a requester under the right to know law. We had another one where there's a group of residents. It was all that the information was given. There was no contact name given. There was no name of a person. Industry residence was not a known legal entity, so therefore not a person. And we found that that also was an anonymous request that the agency could have properly denied. Another group that got together, again, concerned citizens of West Easton, maybe a little more specific than just residents, but not necessarily. But again, not a person, no evidence that this was a legal entity. Therefore, we determined that that was an anonymous request and anonymous appeal. In another one that we saw, we had them use a first name and an email address, and we found that using a first name was not sufficient, even with the email address being included, that it was anonymous request and did not qualify as a requester. And then we had one, you can't have anonymity without having a John Doe involved. I'm sure that there are any number of legitimate, real people named John Doe, but in this case, there was no evidence presented that this was a person. There was no evidence presented that this person actually existed and was actually named John Doe. So we found that that was an anonymous request. I would encourage you. There's a large list of these within that we have faced over the years. It's not a new, this is the issue of anonymity is not a new issue that's come up for the OOR, but it is one that has become much more prevalent. I would encourage you to go to our docket search, type in the word anonymous in the description field, and if you hit submit to that, you will get any number of appeals that might be able to give you some direction and guidance on, you might even find one that's specific on point with a name that's being brought to your agency, and then you can look at that final determination and use that as some guidance for how to navigate answering that request. So some of the ones that we have found where they were not anonymous, that these were legitimate requests, was Jason Delt. Agency denied the request as incomplete and anonymous because the requester did not provide a mailing address or a telephone number. The requests made by this requester included a full name and an email address. There was no indication from the agency that there was any challenging that this was not a real person. So based upon the fact that he had provided a full name and a email address satisfying section 703, we found that this was a legitimate request. I want to point out too that the township in this situation again presented no evidence, so that was our decision. We'll see some cases coming up where the agency did present evidence and what type of evidence we look for to find that a request is anonymous. So we get into what ifs, and we've had a number of calls on these about what if this happens, what if that happens. I want to emphasize that this is a new it's not a new area, but it is becoming much more prevalent, and the emergence of AI, as you all know, I'm sure, is changing many things, not just in right to know, but across any number of government entities, agencies, the way government does things, even the corporate world. AI is really an impacting thing. So as we go forward, these things may change. Legal arguments are going to be made as to due process rights, filing things via proxy. These are all things that are legal issues that are going to be worked through. So I say all these what ifs with a caveat, and there's probably going to be many more what ifs after this. But what if a requester uses an automated system? And as we talked earlier, we have seen that come up across the state, and it's come up nationally as well with any number of entities and companies starting to use these automated systems. But what if they use that to conceal identity? And we faced that in a recent final determination, and we said that individual requesters are permitted to file requests using their own name. However, the use of a tool, process, or entity that creates an anonymity or has an anonymous function so that it will allow requesters to remain anonymous. We found that request was anonymously filed, and even if there's an identity attached to that request, the fact that the anonymity remains behind the scenes, that still qualifies as an anonymous request. And what if a requester used what appears to be a real name, but the agency reasonably suspects they are anonymous? How can I prove that? And a good one to look at for how to handle one where you have a suspicion, it's not just enough to look at it and say, oh, I don't believe this person is who they say they are. It's not enough to say that's a suspicious sounding name. There's a little more evidence that you're going to have to provide, and the next couple FDs will show that we're going to talk about. But there was an internet search. The agency did an internet search for this person's name, and only found reference to deceased individuals. The IT department could not confirm that there was any person behind the email address. And based upon that evidence, we determined that the person making the right to know request was anonymous, and found that result. Another one, which was a little more complicated and in its approach, was a request was filed with an agency under the name of J. Dino. Or Dino. Second request was from a John DiNicola. And the address he gave was on Plain Street. They found that there was only 3 houses. They did a further internet search and determined that who the owners of the occupied houses were. They weren't named as person. They searched the internet for the person and the relevant zip code. They couldn't find any information there. They went through some of the tax records, as you could see. And it outlines a couple more things that they did, but the agency went in, looked in, trying to confirm whether or not this person was legitimate. At the end of the day, there was no evidence that this was a real person, or at least was somebody using a different name and a fake name. So that was the result of final termination, that this was indeed an anonymous request. So what are some of the things, and I want to take a step back real quick. As an agency, if you get a request that is anonymous, or you suspect is anonymous, I think it's very good to take it seriously. And you look at the steps that you have to go through to show to the Office of Open Records that it is indeed an anonymous request. You're obviously not going to want to do this with every request that comes in. So that's where I emphasize using the common sense and reasonableness factor. If you have no reason to suspect that this is an anonymous request, then process it like you ordinarily would. Additionally, if it's information that is clear and on its face public, even if it's an anonymous request. So say you get a request for a budget or something on your website, even though it may be an anonymous request, even though your policy may allow you to deny that, good government, just, give them the budget. Now we get into a totally different situation when we get into redacting and going through, many records. But if it's an easy 1, 2, 3 generic open public record, I would encourage you to give that to them, even if they are anonymous. But what are some tools for addressing anonymous requesters? And the first, again, as I mentioned earlier, and I would emphasize this, is update your policy. Update your right to know policy and how you're going to handle these. Will you accept them? Make it clear on your website, make it known to requesters that maybe you see on a consistent basis, announce it at public meetings potentially. I think another thing is we're coming up on a new year. This is a great time to review your policy anyway. So even if you already have an anonymous requester provision in there, I would still encourage you, hey, take a look at your policy, make sure it's working for your agency, make sure it's working with the type of requests you're seeing. So just a little quick note there to do that. Another thing you can do is decide whether you're going to accept only the Office of Open Records form. Or are you going to develop your own form? Because the right to know law says that you can require them to use your form and the Office of Open Records form. But if that's not in your policy, you're not going to be able to do that. Requests can continue to be made still really in any type of format. So that's another policy decision you can make that could potentially make your processing of requests easier. Again, keep intent of the law's purpose is to maximize this access. This is a request for public records. So again, even if you're not sure who's requesting them, you can still release the obvious generic public records. I will emphasize that if you raise anonymity in an unreasonable fashion, that could put you in a situation where you're facing a bad faith finding. Or if you're constantly using the anonymity policy that you developed to put up a hurdle, that could be problematic in the bad faith realm. I would counter by saying as well for requesters that if you are misusing the process, there's potential legal liabilities that you could face as well in all of this. So coinciding with all of this, the Office of Open Records has developed a new right to know request form to try to make things more efficient and effective for agencies as they process right to know requests. I wanted to point out a couple differences from the old form that we had. It's now 2 pages long. We moved some existing language around. We made the language clear with respect of do you want copies. The biggest change was that we had a checkbox now affirming that the full name and contact information that the requester provides is true and correct. And also it provides that the requester is a legal resident of the United States. So in rolling out this new form, we wanted to alert everybody that you should be replacing any old forms that you have. The old Office of Open Records form should be replaced. Now, usually, and the easiest way to do that is just link to ours so that when we change it, it automatically changes within the link. But I know some agencies have used the PDF form of it. If your agency has the PDF form available on your website, you do need to change it over to the new one. Otherwise, they'll be using the incorrect form. And again, just emphasizing it's much easier to just link to us to do that. Again, agency policy should be reviewed here to make sure that you have a clear policy that explains how you handle your right to know processes and how you handle the use of forms. So the recently frequently asked questions that we get now with the new form has been these. Can an agency refuse to open email attachments? Because, with the new PDF form, we have not addressed this specifically in a final termination. I would point out that Section 703 permits the filing of requests via email. So requesters can file email requests. The question then gets a little stickier. Can they do so with attaching a document, and does the agency have to open that? Again, we'll look at that when it comes up. Some of the questions and factors we would look at is the attachment a PDF or other commonly used file format that would be less likely to have a virus or security risk to it? Can the agency explain why there's a security risk in opening the attachment? I know sometimes links are included in there too. Is there a security risk that would be prevalent and obvious with clicking on a link? And has the agency provided alternate ways to submit requests to the agency? Does the agency have a portal that allows right to know requests to be filed via a web-based form to be filled out, via mail, via fax? Those are interesting issues that may come into consideration when that issue comes before the Office of Open Records. The more evidence and facts you can give to why you think opening a certain attachment is problematic will be very beneficial to the Office of Open Records. Another one we said is failure to check the legal residence of the U.S. box in the OOR's new form and automatic denial. Again, let's practice good government here. Act in a reasonable and good faith manner. Contact the requester. Let them know, hey, you missed checking the box. The question then is there a reasonable basis for denying it? Do you have something you could support? Because technically the answer is yes, you can deny it. But again, putting up hurdles that lock the access to records that are minor and can be resolved easily, it can be problematic. The agency is not bound to accept a checked box as true. So just because they check it and you still suspect that, hey, this is not a real person or this is a problematic situation, you can challenge that before the Office of Open Records if they bring an appeal. I would challenge you on all of these. If you're raising anonymity or challenging someone's identity, keep in mind you're going to have to provide evidence to support that. But also, if the OR disagrees, you may have forfeited your opportunity to raise exemptions. So make sure you are providing exemptions that you see as being applicable to the records that have been requested. If we find that this is a legitimate request and you need to provide the records in some type of redacted format. And I also want to highlight, if someone checks the box knowing they're misleading, misrepresenting the agency, or misrepresenting to us or the agency, that there are potential legal ramifications, both civil and criminal for such actions. So that would be up to individual agencies probably to take action on. If it was a severe enough situation, the OR could look into researching some of these factors as well for what type of ramifications it may have. Is the agency required to accept the OR's old standard right to know law form? So somebody grabs it from somewhere or has it laying around. Again, technically, you don't have to accept the old one. But again, let's practice good government. You have the discretion to accept or deny it. You may have a reason for it, and if that becomes an issue before the Office of Open Records on Appeal, you have the opportunity to explain that. But again, contact the requester and say, hey, the OOR's standard form changed. Here's a copy. Here's where you can get a copy, and do that before denying it on a technicality. There have also been a couple cases of note that have come down. I'm not going to go into any detail on them because they are very narrow and specific to areas, but I have them listed there. And if they impact your area that you handle right to know requests within your office, I encourage you to go take a look at them and review them and see how they may impact how you process right to know requests in your office. And with that, I'm going to turn it over to Liz for a look at the Sunshine Act and executive sessions.
All right. I'd encourage you. There have been some really good questions in the chat that Jordan is answering if you have a chance to look at that. So switching gears to the Sunshine Act. And if you're not familiar, this is the law that determines how open meetings should occur in Pennsylvania. And one question we have gotten a lot, particularly this past year, is about executive sessions. These are sessions when the governing body can meet in private outside of public view. And the sense I get is there's a lot of anxiety about, are we doing this correctly? Could we get in trouble? What's the way to do this? And so I'm going to go through some basics. And first things are scheduling. When can you do it? You can do it before, during, or after an open meeting, or you can say, hey, we're going to go to an executive session next Tuesday. You can schedule it for some future time. The other one that I think trips people up a lot is announcing. You have to be as specific as possible about what you're talking about in executive session without violating the secrecy of the matter you're talking about in executive session, or talk about that more soon. But just saying, hey, I'm going to go to an executive session is not appropriate. Be specific as you can without violating any confidential issues. For example, we're going to go to an executive session to talk about whether or not we're going to fire, Jane Doe. That's not appropriate, because one of the reasons that termination of an employee is considered appropriate for executive session is because it is something that is sensitive. So be as specific as you can. Here's the thing, is that the public is not completely shut out. They cannot hear the debate, the back and forth, the discussion that people are having in executive session. But however, they are allowed to speak before a public action is taken. So here's what happens. Let's go back to my example. You're discussing whether or not, let's go to an example. We're discussing whether or not to hire a new superintendent for the school district. And they announce that's what we're going in to talk about executive session. That discussion occurs. They then leave the executive session, and the public is allowed to then go and say, I'd like to talk about whether or not you hire this person to be superintendent. And you allow the public to speak. And only then can the final action occur, the vote whether or not to allow this person to become that. So the public is not completely shut out. They're allowed to comment on the issue, but they're not allowed necessarily to hear the dialogue between members of the governing body. One more time, okay. So what is it that can go? What can you talk about in executive session? What are the things that are appropriate? A lot of these things have a lot of common sense. Personnel matters, hiring somebody, firing somebody, discipline. That doesn't mean that no one ever knows if these things happen, but what yay or nay, whether or not you should, occurs privately, and then the body comes out as a body and publicly votes yay or nay. So at that point, you would know that you're going to be firing Jane Doe if you say, should we terminate Jane Doe? That type of thing. Labor negotiations. Of course, if you are having labor negotiations, those types of things, negotiations for obvious reasons tend to be confidential. because of the back and forth and the dynamics of such discussions. Considering purchasing, leasing, or selling a property, again, there's some reasons why you should do that. You want to have that conversation confidentially because there's costs involved. Consulting with counsel about litigation. This does not give you carte blanche to talk about anything you want privately with your counsel, but when it comes to litigation, that is something that you can discuss confidentially. And avoiding violating privilege or confidentiality. Of course, you don't want to violate that. And then a very narrow one that comes to the last one about usually with attorneys. Discussing university admission standards. That is something that is very narrow, but that's something that universities can discuss privately. And then discussing emergency preparedness. You don't want to say this is what we do in case of an emergency, in case that actual action is something that you could make the public less safe. Certainly emergency preparedness should be kept private. So those are the large categories. And a specific question, vote for public funds. I don't know if it's not clear to me what votes might have to happen for that. It's hiring decisions, I think, like a superintendent you do, but deciding whether or not you are terminating somebody, that dialogue can happen confidentially. It depends on how things are run for your agency, whether or not that is a vote or what the position is. But that final action is public. So even if there's not a vote, do we terminate Jane Doe? The fact that she is terminated will eventually become a public record. The reasonings for that remain confidential. So, taking a breath. Do you have questions regarding anything we've talked about here, anything we haven't talked about? Please go ahead and put it in the chat and you'll hang around for a bit and see what happens. And I remind you, I would put our agency against any other agency in terms of being helpful to you. If you call us, if you email us, we will get back to you. We have real live people who answer the phone. It's not press 1 or press 2. As Nathan mentioned, we cannot give legal advice. We can't say, oh gosh, we should absolutely grant access to that record. Oh, they're totally anonymous. We cannot do that, but we could perhaps give you a final determination that might be helpful, or some other legal case that might be helpful. But there is ways we can be helpful. Call us, reach out to us. We enjoy helping as much as we can. We know that dealing with right to know law issues and with Sunshine Act issues can feel intimidating because they are high profile and they tend to be things that seem intimidating, but we can be as helpful as we can. Can you come out of an executive session and add an item to an agenda that requires spending money? So there has been a recent ruling that I believe is still being going to the courts regarding how big of an item, in non-technical terms, you can add to an agenda at the last minute. Last minute meaning less than 24 hours before. So that decision made it seem like there's pretty high bar for adding something at the last minute, meaning it has to be something very minor, but that is still being litigated. But I would imagine something that requires expending money would be challenging in terms of how I don't know how to move the chat up, how adding that at the last minute. So I would proceed with caution. And there's a recent case that
Coleman versus Parkland School.
Thank you. Coleman versus Parkland School District talks about that. They tried to add, I believe, a ratifying the union agreement with the teachers union, and that was determined to be something that was too large of a thing to add last minute. I don't know if I can scroll up.
Okay, the next question is curious about the sunshine notifications in newspapers concerning those sessions and moved board meetings.
Yeah, so this is something that gets a lot of dialogue. There is a requirement that any meeting notification be published in a hard copy in newspapers. And in terms of if things changes, like last minute changes of the meetings, is that correct? I believe you have to make best effort you can. I think if there's an emergency, things can happen, but I believe you have to do what you can to print that in the newspaper. Other questions that I can't see?
Yeah, okay. If you update your township's existing right to know policy, does the Township Board of Supervisors need to approve the policy update at a public meeting?
That would be based upon your internal policy, how your agency handles approving your own internal policies and rules and procedures. There's not any necessarily requirement for that in the right to know law.
I think I've seen a lot of agencies do that in a public vote.
All right, here's one we get quite often. Is there a limit to the number of requests someone can make over a certain period of time?
There is not. There's no ban on frequent flyers in the right to know law.
Okay.
But I would point out that there are, when it comes to many requests or voluminous requests, the court has developed certain standards that allow addressing these. And there are two cases that there's one called Abscuff and the other one just left me. You know what?
Brilliant.
Brelier. Yeah. Abscuff and Brelier are two cases you would want to take a look at for how to handle voluminous requests, and I think they're equally applicable to voluminous or many requests.
If the council has an agenda workshop and advertises it, must minutes be kept, and do they need to be done by the secretary and posted online?
It's a good question. I haven't had that one before.
Touch base with us. We'll get back to you on that one.
So agendas, for those of you who don't know, workshops, they're where a governing body can learn about new things. Like say an expert comes to talk about whether or not we should build this new road. An expert can come, they can talk about it. It can be something that the governing board asks questions of the expert. The governing board may not engage in debating the merits of that decision. It's just information exchanging.
Legislation update on right to know.
So there's a new, how do I say this? There's a new new legislators coming in. They do sessions, 2-year sessions. So the new session will be starting in January. A lot of change in legislature. So everything starts from scratch. So if there was a law, a right to know law that you were interested in following, it has to be reintroduced. It'll have a new bill number. I've been monitoring the new legislation that has been put up. I haven't seen yet any of the new right to know laws, but there's kind of a flurry of new things that happen in December and January. So I imagine there will be several pieces of right to know law related legislation that will be reintroduced going forward. And so we will, if you have questions, you can search for that term in legislation. And that is something that you just have to keep atop of. And if you're a member of the Township Association or Borough Association, they're a good resource to keep in touch in terms of what legislation is out there.
At one of our recent meetings, we had a citizen begin recording our meeting. Another citizen attending didn't want to be recorded. Her response was, well, it's the Sunshine Act. I can record. Any insight on this?
Yes, they can record. And it's a public event, and public events recordings can occur.
There's no expectation of privacy. Any results on the Commonwealth case last week? Do you know anything about? No. And if it was just argued last week or filed last week, it'll be a while before they issue any type of decision.
Okay, Walt wants to know, it says the members of the agency need to be notified of the executive session 24 hours in advance if it isn't announced as a meeting. Does that include all members of the agency that are required to be at the meeting, such as personnel issues and the employee will be required at the meeting?
I mean, if memory serves me, I believe it's just letting the members of the agency know that they need to be there because of 5 of the 7 are only the ones notified and they can't come to executive session. But I don't know if that has been fleshed out in court case history.
Will the slides be emailed to attendees?
Yes, there is a link on our website that has, you can download the website. Jordan, could you put that in the chat again?
But we won't email it to you specifically,
No,
right?
but you can access it on our website.
And the case I mentioned was it's AppScuff, which is a acronym APSCUF, I think, but it'd be better to reach out to me or reach out to us so we can get that for you, because I don't know the site right off the top of my head. So yeah, please feel free if you have questions about that one too. You can just email the main box and we'll provide you with copies of those decisions.
So for executive session, and again, I'm not trying to be cute here. We cannot give legal advice. You need to be as specific as you can about what you're talking about violating the reason that it's confidential. You can say, you can't just say we're going to executive session to talk about stuff. You have to be as specific you can. Again, I'm not trying to be unhelpful, but I can't say how specific to be. But so the public has a general idea of what you're going to talk about going forward. Put up a sign in a meeting letting people know it's going to be recorded. Yeah, sure.
Nothing prevents that.
Okay, the question is, what if the requester wants photos of items or areas? If photos do not exist, we do not have to make photos. Nope, you do not have to create a record that does not exist. Yes, Zach, they can't just say, okay, executive session. They have to say something related to HR issues or that type of thing. You can't just say executive session. It has to be some category. So they know which of those categories that you currently see on the slides you're discussing.
With respect to cases on how specific an agenda has to be, there's no new cases. And unfortunately, in the Sunshine Act area in general, there's not a lot of case law guidance.
There's one about Reading's newspaper, Reading Eagle.
Right.
Reading Eagle does talk about, and if you reach out to us, we can send you the specific case. Reading Eagle, there's a case about executive session. Can the purpose of the executive session be announced at the meeting? Or must it be announced 24 hours beforehand? I don't think there's been any case history on that.
No.
Julie asks, can a school board meeting that has been recorded be given to the school staff prior to the minutes being approved and ratified in the following board meeting?
Sorry, Jordan, could you repeat that one more time?
Can a school board meeting that has been recorded be given to school staff prior to the minutes being approved and ratified in the following board meeting?
Given the recording, given beforehand? I don't think there's anything stopping it from happening.
Yeah, I'm not entirely certain what's being asked, but I think the courts have been pretty lenient in allowing boards to ratify past actions. So. There's a very common one. If a requester submits a right to know request and the agency is requesting a 30-day extension, is the 30 days based on the requester's 30 days or the agency's 30 days?
It's 30 calendar days.
Yes, 30 calendar days, not 30 business days. So
neither the requester nor the agency. It's a standard set 30 days.
Yeah. It's those initial 5 days that are business days, and that would be the agency's business days. So if your agency, for example, was closed the day after Thanksgiving, that would not count as a business day, even if for other parts of the world it's not.
Right, in response to it.
Yeah. Could you talk about the second one too, the criminal?
Yeah, absolutely. Does a criminal investigation have to be active to be considered for denial under B16? What if it's already gone through court or is after the appeals timeline? It does not matter. The criminal investigation exemption does not expire under any circumstances. And therefore, it doesn't matter if the case is done, if there's been arrest, if there's been appeal, it's going to remain exempt.
Can an agency just do a 30-day extension on all of their requests? If not, are there consequences for doing it? We have not seen any case history of consequences, have we, Jordan, for that?
No, generally speaking, we don't have the authority to say that an agency has done a 30-day extension improperly, although there is a statutory requirement for how they invoke the 30-day extension, and if they do that wrong, then the 30-day extension is ineffective. But we have not found an agency to have been acting in bad faith simply for taking a lot of extensions. And I'm not aware of any courts that have done so yet.
I would say I have seen some media publications that can be critical if an agency is found to do that a lot. So there may be some PR consequences. Training, I know the OR doesn't deal with Act 22 requests, but do you know if they're of any training for that? I'm not aware of any training for that.
No, we have an Act 22 section on our website that outlines how the process works. So you could reference that.
Consequences for what, if any, are the consequences for a council person discussing executive session issues with the public? I'm not sure. I guess perhaps in the ballot box there might be consequences. I'm not sure if there's any technical legal consequences beyond, again, some problems with the public. Say one more minute. If records officer is on vacation and lists another contact for a right to know request, but the requester does not send to the secondary contact, are there consequences for not responding within 5 days? First of all, this is one reason we encourage what they call a resource account. Rather than Liz Wagenseller at Open Records or Nathan Byerly, it's just right to know request at Open Records. That way you don't come into this problem. So that is a best practice. But in terms of what happens if the backup person, the requester does not send it to the right person, Jordan will answer that.
Yeah, so if somebody is out and there is a backup, then the backup can receive those requests and the timeline starts immediately. If the records officer is out and you send it to them rather than the backup, then the clock starts ticking on the day they come back and receive the request, which does mean that you might not actually know when your request was received, which can create some problems, which is why it's definitely best to have an alternate and have them clearly posted on your website so people know.
The board can censor them. Well, I don't know that, perhaps I don't know the governing rules for different people in terms of the consequences of doing that. I'm not familiar with that. If the 30-day extension deadline falls on a weekend, does the extension move to Monday, revert back to Friday, or does the deadline remain on Saturday or Sunday?
Yeah, it will fall on the next business day. The request, you never have to respond to it over the weekend or when you're not in business. The 30 days, or the 30 calendar days can keep going, but the day that you respond will be the next business day after the 30 days expire.
Yeah, and then someone commented that in Berks County, a township there, they removed an elected supervisor for revealing executive session. Yeah, there may be consequences. I'm just not familiar with the rules in those governing bodies regarding that. If a requester asks an openly vague question, I believe, is there an agency required to contact the requester to seek clarification? Jordan, would you like to answer that one?
Sure. We encourage you to do so, as that's probably going to be the easiest way to figure out what they want and get it to them. You are not required to. You may immediately respond saying this is insufficiently specific and denied for that reason. But we do encourage you to reach out and try to work with them instead, because that's going to get you to a better place.
One of my favorite stories I heard from a township supervisor or township manager is that they got a request regarding a bunch of financial records, and it would have taken their agency tons of time to fill this request. It would have cost the requester lots in photocopying fees. And so he decided, I'm just going to call her because I don't quite understand what she's getting. And it turns out when he called her, all she wanted was how much they spent on snow removal each of the past 3 years. 3 numbers is all she wanted. But not everyone speaks bureaucracy. No one ever knows exactly how to ask the question to get. So by having that phone call, he was able to give her exactly what she needed, and no one, and we did not have the time and money spent that would have been wasted. Now I have lost the scroll. So Jordan, if you could please say what the next question was.
Yeah, absolutely. Walt asks, if the only open records officer is out for a long time, say 15 days or a month, does the requester just have to wait till they return, or is the agency obligated to make a good faith effort to try to handle the request?
What'd you say, Jordan?
That's not an issue which we've ruled on, and I can't give you a certain answer. The agency is required to have an open records officer and respond to one, so if they went long enough, I could see a plausible situation where they would be told that they were in default, but that hasn't happened before, so I can't tell you how long that time would be. Okay, several people are asking, can you request multiple extensions? How many times can you request an extension? Is there a limit on the extensions? The answer is that an agency may invoke a 30-day extension as long as it meets the requirements under the statute, and then they can ask the requester for any number of further extensions, which the requester must agree to in writing before the last day of the current extension.
There are lots of questions about what happens if someone's away. How long can they be away? Go ahead.
For the school districts and breaks, it depends on if the school office is open, because I know some school offices will have business days that they're open. So if the agency is open for business, then that would come into play in that factual analysis if that came before the Office of Open Records.
In terms of other things, someone's away for a while, I would just say use common sense and be able to defend whatever you do but we can't give specifics like, 15 days is too long to not answer, or 30 days is too long for someone to be out and not answer. Just use common sense and figure out, is that a sensible solution for that? But you should always have a backup, unless if you are a teeny tiny borough with 3 people, you should probably have a backup even then.
All right, they ask, if a right to know request asks about a donation from a specific person that was given to a municipal entity, such as a public library, is that covered under B13?
Could be.
Maybe. It may well be.
Don't know. Have to look at all the facts.
Exactly, that would be very fact specific. All right, if the only version of a copyrighted plan is scanned, does the agency have to print it out for a requester to view, or can the plan be sent/emailed as a responsive record? Generally speaking, you're gonna have to print it. The right to know law doesn't require you to do that, but the Copyright Act may. So generally what ends up happening is you have to print out the copyrighted material and the requester can come in and look at it. Because the right to know law lets them look at the copyrighted material, but the Copyright Act prevents you from reproducing it.
If you get a right to know request, you have to read it now.
Jump.
All right, if you get a right to know request and it requires a lot of time and work on the agency's part, and you call the requester and the initial request is what they want, do you have to fulfill that request? Just request extensions. There are only 3 people in my office. It would take forever. Okay, so this is an issue which does come up from time to time in that very burdensome requests can happen. And you should work with the requester first off, see if they can narrow it down. But if they're unwilling to do so, you may be forced to just do your best with the time that you have. And if they file an appeal with the Office of Open Records, Nathan mentioned earlier the APSCUF case. You can ask for what's called an APSCUF extension, wherein we look at this and say, as a matter of due process, the agency is going to need way more time than what the statute has given them in order to fulfill this request, and we'll hash out what the appropriate extension time is and so forth. Unfortunately, the right to know law does not allow you to deny a request simply because it is burdensome, but a lot of very burdensome requests are also insufficiently specific.
We have time for just a few more questions. Jordan, you can keep going.
Okay. Can requesters take photos while inspecting documents?
It depends.
It depends, but only if they wouldn't otherwise be able to copy them. They can almost always take photos of documents that they're inspecting.
I think the exception would be copyrighted information, but they go, like, some people want to go look at textbooks
That's
in a school district, and it's photocopying them is may not be appropriate there. Yes,
All right.
Walt, you're correct.
Murphy asks, can you add costs for labor? The answer is generally no. There are certain circumstances where if you are absolutely required to engage a third-party contractor to answer the request, then you can charge for the contractor's services, but that's extremely rare. Do not count on that happening. Okay, do the right to know request forms submitted need to be filled out by the agency and filed, or will the legal response and records be sufficient? I think what you're asking is whether you have to fill out the form and submit it to the requester along with the response. There's no particular requirement for what your response has to look like other than the few things required by the law. Are Open Records offices required to continually scan spam email for receipts of requests?
Not sure I understand that one, so you can follow up with
I
me?
think they're asking, do they have to keep checking their junk folder to see if they got any new requests? To the extent that that's practicable, I would probably do it because it's easier than if you get a sudden appeal out of nowhere later that you're going to have to answer. But, you don't have to go crazy over it. Just use it, like so much else, this is use common sense, best judgment type of thing.
Yeah, because what will happen in that situation is if the requester doesn't get a response and they appeal to our office, we're going to reach out to you, and then you're going to have to respond to it anyway, and then you're going to be under a stricter, I don't say stricter time deadline, but you're going to be under a time deadline that you're not in control of, like you would have been if you had checked your spam box.
All right, each colleague gets the last question.
All right, what is the protocol on redactions for bids on pricing if the company disagrees to release the information? The way that generally works is that oftentimes the company, when they're submitting their bids, will mark stuff that they think should be redacted in various ways, or if not, the agency will reach out to them when they get the request, and the company will tell them what they think should be withheld. Be careful about this because the agency is still required to use their best judgment in determining what's exempt. They can't just rely completely on the company and say, oh, they said redact everything, so we redacted everything. So that would definitely be a situation where you're going to want to run the case by your solicitor when it comes in.
Okay, you guys give good questions every time. Things we have not thought of, things we've not gotten across, so thank you for stretching our minds and giving us things to talk about. And I hope that this was helpful, and it's available, the recording will be available soon, and the PowerPoint is available now. Reach out to us with questions whenever you have them, and we will be as helpful as we can. Hope you all have great holidays and a happy 2025.